And I think when you're in a situation where you're going back and forth between custody and shared parenting, the term that comes up over and over again is the best interest of the children. That is what the court is going to be looking at, is what is in the best interest of the children. And you're gathering evidence to show that one thing or the other thing is or is not in the best interest of the children. And the process by which we do that is an attorney, usually an attorney, is appointed. They're called a guardian ad litem. They do an investigation, and at the end of that investigation, issue a report and recommendation saying what they believe is in the best interest of the children.
And to be very clear, they're not representing your children. They're representing your children's best interests. Mm-hmm. We've had some situations before where what is in the children's best interest, according to this one attorney, is different than what the children want. And in that set of circumstances, there is the possibility of getting a second attorney appointed to represent what the child wants.
And working with guardian ad litems and gathering evidence and presenting it to the guardian ad litem and the court, who ultimately makes the decision, is definitely an art.
Yes.
And definitely something you shouldn't be doing by yourself.
No.
Because, I mean, again, it's this mix of like personal, your life and your kids and emotion and law and not knowing what's important, what is important, what should I tell the guardian ad litem, what should I not tell the guardian ad litem, because there's definitely some risk in not reporting stuff, but there's a equally big, if not bigger risk in over-reporting, because then you might come off as not crying wolf, but maybe a little bit of that is you think this is important, and now because you've voiced to the guardian thinks that the other important things you're saying are not, like you just don't get it.
You're trying to triage in level of importance, going back to the best interest factors. What does this person need to know, and what will assist them in making a determination that's proper for your kids? And I mean, we're all coming back here to what's best for your kids. And so the crappy things this person has done to you, not really important. However, if it's done in front of the kids, if it negatively impacts the kids, if we can show that it negatively impacts the kids through counseling or some other means, then yeah, we should be talking to them about this.
And in front of the kids is an important thing, because we get so many people where you tell them exactly that. Your fights with your husband, I mean, don't overload the guardian with it. They have hundreds of cases, and if you're the annoying person who's just complaining about her husband, they're not going to listen to you as much, or they're going to dread your emails. But if you can tie it to a fight in front of the kids, or he was treating me this way, and then afterwards my son was scared and wanted to go see his counselor, if you can tie it to some impact, that's important, because they don't care if you guys are fighting. You guys are getting divorced. So that's, right. I mean, almost
a given.
Yeah, right. And so tying it to how is our drama affecting the kids, and even that you want to be careful with, but there has to be some impact on the kid. Otherwise, the guardian doesn't care and is going to stop listening to you. And that's the danger zone.
And that's why we're such a valuable asset, because, this is an emotional time for you, for your kids, for your soon-to-be former spouse. And so we really want to be that filter. We want to be helping you determine what's important, what other instance should we package the specific incident with, and, how should we present this to the guardian, and when should we present this to the guardian? And, because timing is everything, and comparing it to other situations, showing a pattern is extremely important in most of the time. One of the first things we do, going back to the best interest factors, is, show our clients, this is not some mystery formula. This is codified in the ORC, and showing them what the best interest factors are and talking about it together, so you can also use your judgment and determine what's important and what's not important. So, moving forward in a custody battle isn't just us working alone, sorting through everything. It's us working together to present this to the guardian.
It's one of those things where you might think, like, I'm a parent, I should know what's important and not, but you don't know the law.
Right.
And so that's like a difficult thing to square. It's like, I know what's good for my kids, I know this is hurting them, but presenting it in an organized way is really important, and keeping the guardian engaged and not overloaded and not dreading the emails from you. This is what it is turning your personal life into a legal case, especially in cases where there isn't the mental illness, where there isn't the physical abuse, where it seems normal, like quote unquote normal. Why do you feel so passionate that you need custody in order to protect your kids? Without those big stressors, a guardian is not going to get it unless it's presented in a way that is tied to the best interest factors, that is presented in an organized way where, hey, I know you guys are pushing for shared parenting, but custody is what these kids need, and you need a lawyer to help you with that. It's impossible to do it on your own.
Right. And I think, so the next question I think that follows from all this is, why is what the guardian thinks or says important? Because it goes, they, formulate it in a what's called a report and recommendation. It's filed with the court, and the court uses that report and recommendation to issue their own final order. So what the guardian thinks is very important, because the court is likely going to rely on it when they issue their ruling as to what the custody arrangement should be.
I mean, I guess the other thing to think about, just from a purely logistical standpoint, is, the judge or the magistrate, whoever it is who's hearing whatever motion is that's before the court, or, hearing it, they are not in your life. They're not saturated in your life every day like the guardian is. And they know that. And so they're going to be relying on the guardian to kind of act as an arm of the court, as like the court's person who's involved in your life. So they are definitely taking what the guardian says, at a pretty high level.
And they know the guardian. And so
of course.
So they're more prone to trusting the guardian than your own words. It's one of those things where proof. If the guardian says it, there's a little bit more credibility with the guardian than with you saying it. So if we can get the guardian to say what you're thinking, great. If we want to give the guardian your pediatrician, we want to give the guardian the counselors, we want to give the guardian all this information, which you think, and which the people in your children's lives think. So we'll have the guardian go interview the coach or the mentor or whoever it is that's important. And the guardian saying it, as opposed to you or these people, is worth more. Yes. That's kind of our value also, is we know very likely any guardian that's going to be appointed to your case in any county. And so when we talk to the guardian knows we're doing this filtering process. So if we're sending an email, we're not, when they open it, it's not, is this going to be important or not? Or is this going to be whining or not? They know coming from us that this is tied to a best interest factor that's going to go in my report. Hari and Katie and Natalie aren't wasting their time sending me an email. This is important. Let me look at it. So that relationship is hugely, hugely important, both us to guardian and guardian to court.